people to see, but was talking about other lands outside the park. So you were close to the historical marker within 100 yards. You dug a hole so that they banned all the parks in the county, both in Harris and Travis County. We also had the cities of Austin, Henderson, and Calvert, Texas, banning metal detectors in their city parks. Austin's had a problem for a while in their city parks, but Henderson, I know, has been closed for about 5 years to city parks, and there in Calvert, I'm sure there's other city parks in Texas the same way, as well as in other states. So that's kind of just a quick run of what's going on right now. 17 different places in the United States all at one time here suddenly starting to slam doors, banned, and we're going to stop this metal detecting bit. Sounds like a conspiracy, doesn't it? I want you to understand the federal and state laws before we go any further. And I'm going to do a short synopsis of the laws so you understand what's taking place. There is a law, a federal law called ARPLA, which is the Archaeological Resource and Protection Act of 1979. That is the law that describes what an artifact is. In that law, it specifically states that any coin, rock, mineral, or bullet is exempt from ever being considered an archaeological artifact unless it's in the content of a historical site that has been noted as such. In other words, you dig a coin, you can never, I don't care how old the coin is, it can never be claimed as something of archaeological significance. It will not be and cannot be, and neither can a bullet or a rock or a mineral. That's specific in the law, but that is federal law. Federal law also goes through the punishment routine of what you get if you don't abide by the federal law and so on. Antiquities law, that's what we're getting the worst of. And the antiquities law, matter of fact, I'd like to read a part here on the antiquity law, but the antiquity law is specifically for landmark. I have my paperwork here. Anyway, to make it short and tell you what it is, we had our attorneys look into antiquity law. Antiquity law basically just protects landmarks. Has nothing to do with artifacts. Does not have anything to do with digging. And by all rights cannot be used to remove you from a public lands, state, federal, or city. They can't use that law, but they are. They're counting on you being stupid not to know that. But they can. They're doing that right now. And most everything that we have here in Texas, they're using the antiquity law on. What we're seeing over in New York and Louisville, Kentucky, the antiquity law again. But if you read the law, and I did bring a copy of it, if somebody wants to thumb through it, it's too many pages to otherwise. As a matter of fact, I can pass that out here. Yeah, antiquities code. Just to start this around the room, let everybody take one, just the antiquity code. If you read the antiquity code, it specifically talks about landmarks and not anything to do with metal detecting or having the hobby of on any lands that they're overseeing. Antiquity law only oversees, and so does ARPA, government lands, or government subsidy lands. So if it's a part of the government in any way, whether it's city land or whether it's state or whether it's federal, then that's the only place these laws pertain to. They do not pertain to private property. Private property, if you've got the permission of the owner, it's not a thing they can do. They can and they have intimidated the private property owners in the past, even threatened higher income tax, stuff like that. I was at a battlefield one time in Alabama. The neighbors at the battlefield were all visited by the parks people telling them that they were going to see that their income tax was doubled next year if they didn't go along with them by keeping relic hunters off their private property. So, you know, anything they can buffalo you into, here we are again, you're supposed to be stupid. So if the Antiquity Act, you'll have a copy of it there. You can look it up on the internet. But again, you'll find out that it has to be landmarked. Now, for any of that to be landmarked, for any site to be off limits or considered under the Antiquity Act or any other ARPLA law or anything else. It has to be surveyed. It has to be proven of historical significance or archaeological significance. It has to be. Now, if it hasn't been surveyed, and if it's a park, it had to be surveyed. You couldn't build a park until it was surveyed. The Historical Commission usually is in charge of the survey, and there is a site on the internet called wildcat.org. Wildcat.org will show you any state, federal survey done in the United States. You can look it up on wildcat.org. If it's had a survey done, then it determines whether the site is actually of archaeological significance or historical significance and can be restricted if that happens. Just like the Corps of Engineers, they have that in the policy that we have with them. If the district manager of the project office finds out that there's something there, like a Pantaleon site or something of that nature, and they discover that, they can stop us from hunting where we've been hunting all this time because of it, to preserve that site. I don't think there's anybody in the room that's against preserving sites. We like our heritage, we want to benefit from it, but let's be true, people. Archaeology is non-existent in this country. This country is just barely 200 years old, you know. If you graduate archaeology, it's overseas, you know, before Christ. Let's go over there where there's archaeology. What is it that we didn't do that we don't know the history of here in the United States already? You know, if it's a specific battle or something like that that they don't have much written on it, that's fine, but we've been record keepers for 200 years. I just really don't see the point of calling it archaeology over here. I call it relic hunter chasers over here, because that's the only way they can get their name publicized in the archaeological magazines, is that they captured one of you or arrested you. It's hard to get any money. Their archaeologists are interested in the money that they can get for a project to do and keep an ongoing flow of money. But if they can't do that, well, then you're the next subject. So, but also a landmark, anything that's been surveyed and found of significance, has to be placed on the National Register. If it is not on the National Register or has been applied for and yet to be approved, then they can keep you off. If it's not on the National Register, they cannot. But I mean, you got a choice. See, here's our problem. We can either go against the law officers and rangers standing there, which would not be a good thing. We would be arrested, and plenty of them, in several cases, have been arrested falsely for the very fact of trying to buck them. Or we go home and we do something about it somewhere down the line. And we'll talk about that here in a minute. Some of the problems that we've had in the past years that set precedents that hurt this hobby was like the Billy Shivers case. In the Billy Shivers case, which he ended up losing, he went all the way up to nearly the last step would have been Supreme Court. He lost it, and what it set for a precedent that was all surface fines become property of the government. When that happened, here the gold mining, coal mining people, all of them started getting upset then, because their surface mining is coal and gold out there, and now it's considered property of the government. Anything they find on government land is now theirs, whether it's on the surface. ARPLA says that if it's an arrowhead, a rock, a mineral, or a coin you see laying on top of the surface, with no excavation, you can pick it up. But now, with this, what the governments are trying to do now, and regardless of what ARPLA says, the federal law says, they're trying to create their own laws, their own interpretations, which are not in the wording of the law, and arrest you anyway. So they're going to arrest a Boy Scout for picking up arrowhead? We hope so, because I'd like to see that one on the news, you know. But that's what happened in the Billy Shivers case. They used his case specifically. The focus of his case was not to prosecute Billy. The focus of his case was to get a precedent set where they could arrest you for picking up surface fines, which is against federal law to do that. It's written in the federal law that you can do it. Next one was Bob and Ed case. The Bob and Ed case that a lot of you have heard about over the years, it happened 5 years ago or so, where they fought it right here in the state of Texas.